We are back. I am your host, Dave, 10-year intellectual property attorney, dealing with everything from trademarks, trade secrets, patents, as well as copyrights. And today, we have a very important one. The Copyright Office seems to be bending a little bit on the rules of what's copyrightable subject matter. Now, for those of you who don't know, a copyright can be a book, it can be a 2D artwork, it can be a motion picture. Think of movie, TV shows, sound recordings, lyrics. A lot of those things kind of fall within a subject matter of a copyright, but it has to be a work of authorship that's fixed in a tangible medium. And that work of authorship has to be a work of human authorship that's fixed in a tangible medium, which means that typically works of art created by AI, artificial intelligence, is not eligible for copyright protection because it's not a work of human authorship. Yes, a human is giving inputs, but the actual artwork or the output is created using AI and not a human. However, it seems like we're going to get off into the article here where recently the Copyright Office, which handles U.S. copyrights that are filed here in the U.S., had just said that you can get a copyright on artwork using AI if there's one condition is satisfied, which we're going to get off into here in a little bit. But before we do, I wanted to, let's see here. There it goes. I want to pull up this article. Not an article, but this picture. And I actually did a fuller breakdown on this picture. So please go to I think his name is Jason Allen is the artist. Yeah, Jason Allen. He's out of Colorado. Please go to that full video to kind of get more of a detailed analysis of what happened in this video. But again, you see the artwork. This gentleman, it was a digital art competition in Colorado, and this gentleman, he submitted artwork that was generated using AI and won first place. You see the ribbon, the blue ribbon to the right of the artwork. It says first place, Colorado State Fair, or Pueblo, Colorado. I think Uncle G was in there one of those shows. But anyway, so he wins first place. This guy, Jason Allen, is talking about how art is dead. AI is going to be taking over. And the irony of that statement that he was saying was, again, mind you, up until this point in time, AI-generated photos were not copyrightable. So months later, he's selling his artwork, his AI-generated artwork, making money. But again, since it's not protectable via copyright, other people, such as you and I, other people were selling his artwork as well. Now he's complaining, talking about, hey, people are stealing my artwork. They're making money off of it. So now people, the people who I would kind of usually will pay me for the artwork, they don't have to come to me anymore. They're going to other people who are selling the same thing. And again, that's the yin and the yang of it. It's one thing when you're making artwork and you win state shows and talking about art is dead, but on the other side, when it's kind of costing you money, now you're complaining because again, it's not copyrightable subject matter. That's why this IP stuff is extremely important, because who owns it? Who can anyone protect it? And to the extent that AI is producing artwork, then it's not protectable. So that's the backstory on this artwork, which I think is a pretty dope piece, but it wasn't protectable. Therefore, the Jason Allen, the artist who came up with it, was losing out on a lot of money as a result of not being able to get the copyright. Now we're going to pull up this article from this particular article is from The Hill. Let me see here. There we go. I don't like that, man. Let's do it. Let's do a full picture. Here we go. So this is from The Hill. This was what, shout out to Sarah. This came out January 29th. So, about a week or so ago. And this, as you can see, artists can copyright works made with AI assistance. So it seems like the Copyright Office is going back on what they were originally saying. Let's see what you need to do to be able to get copyright on AI assistant or AI generated works. So artists can copyright work they create using tools powered by AI as long as sufficient human creativity is involved, according to a new report from the U.S. Copyright Office. So as you can see here, I'm going to bring it back on myself. It has to be sufficient human creativity, whatever that means. Let's get back into it to see if the article kind of gives us a little bit more detail of what that means. The report sought to address questions of copyrightability for work created by AI or with the help of AI-powered tools, amid an uptick in copyright applications for AI-generated work. So it seems like the Copyright Office has been getting a ton of submissions for copyrights of works that were generated from AI, which again, typically they would deny because you cannot protect the work that was generated using AI, which is interesting because, man, I have had a lot of people come to me talking about, hey, I'm creating a book using AI, or I'm creating a movie using AI, or this artwork using AI. And I typically say, I mean, that's all cool and fine, but just know you're not going to be able to protect that. So again, you can sell that book or sell that artwork or sell this or that, but if somebody tries to come after you for copyright infringement, or somebody uses your book or uses your artwork to sell it as well, you cannot sue them for copyright infringement because you don't own a copyright, because the work is made from AI. So this stuff is extremely important, especially when you're talking about making money. Let's get back to the office here. So it seems like the Copyright Office was getting an uptick in copyright applications that they at least at this point in time they had to deny because it was using AI. Copyright Office said it makes decisions on a case-by-case basis, but clarified that it will approach such questions by examining the degree of human input and creativity in each work. According to the report, an artist's work may be copyrightable in whole or in part in circumstances where AI is used as a tool and where a human has been able to determine the expressive elements they contain. Man, you're talking about subjectivity. However, work generated entirely by an AI system will not be granted copyright protection. For example, works created by a chatbot or AI system in response to someone's prompt at this stage are unlikely to satisfy those requirements. The use of a machine as a tool does not negate copyright protection, but the resulting work is copyrightable only if it contains sufficient human authored expressive elements, the report said. The report follows an extensive review of copyright law that also invited input from artists, AI developers, and other members of the public interested in laws application in AI technology. Let's finish up here. The report concluded that existing laws are adequate and appropriate to resolve questions of copyrightability, and that no additional laws are needed despite the proliferation of new technology. Copyright law has long adapted to new technology and can enable case-by-case determination as to whether AI-generated outputs reflect sufficient human contributions to warrant copyright protection. So again, essentially what this means is if your work was done wholly by AI or an AI system, you're probably still not going to be able to get a copyright of that. But if your work has this, what they say, let me get the language correctly. If your work has sufficient human authorship, then it can get a copyright even though it was you use AI to produce it. Who knows what sufficient human authorship means, but that's what your work needs to have if you're trying to get a copyright on some type of creative work, picture, script, whatever the case may be that use AI. And the unfortunate thing about this is this is going to come down, and I deal with this all the time with the United States Patent and Trademark Office on the patent side of things. It's going to come up to your examiner, whoever's examining your artwork, your copyright application. If he or she believes that the human authorship is sufficient human expressive human authorship, then you may be lucky. But if they're having a bad day, then that can affect your being able to get that copyright for that particular thing. So sufficient human creativity is the standard. Let me know what you think about that. Like I said, I still think that's very subjective, and that kind of really doesn't kind of clarify the point. But again, that's my thoughts as an IP attorney who's been doing this for 10 years. Let me know your thoughts in the comment section. Please hit a like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community where we talk about this stuff. And I'm going to continue to talk about it to see if kind of the standard becomes a little clearer, because just saying sufficient human creativity, what does that mean? It seems like that's very unclear and murky, if you ask me. But again, that's what the Copyright Office has said up until this point in time. So hopefully you guys enjoyed this video. Please hit the like button as well as the subscribe button to be a part of the IP community, and leave your comments in the comment section. I would imagine that a lot of you probably agree with it. Do you disagree with it? I would love to hear your thoughts in the comment section. And until next time, you guys take care. Peace.